Hi, everybody. My name's Mike Rappaport, and I'm the director of the Center for the Study of Constitutional Originalism. And I would like to welcome everyone to the lucky 13th annual Hugh and Hazel Darling Foundation Works in Progress Conference. I say the lucky 13th because I believe we have been fortunate in recent years with the conference. This year, Omicron has subsided enough that we are able to have an in-person conference. In 2020, the conference happily preceded the lockdowns by less than a month. And while last year's conference was on Zoom, it did allow people to talk between sessions and to eat some meals together. Still, it's great to be in person again. Every year at the beginning of the conference, I use this time to highlight what I regard as the most important events concerning originalism in the past year. Perhaps the most important event in the last year has been the performance of our newest Originalist Justice, Amy Coney Barrett. There has been no scarcity of analysis of her performance so far. Some see her as part of a conservative originalist bloc. Others see her as part of a new 3-3-3 court of 3 conservative originalists, 3 progressive non-originalists, and 3 moderates, with Barrett among the moderates. In my view, Justice Barrett has been a genuine originalist in her first year, one who's been both careful and thoughtful. Perhaps her most important opinion was a concurrence in Fulton versus Philadelphia, where she seemed to agree that the Smith non-discrimination standard should be replaced, but did not join Justice Alito's opinion applying strict scrutiny because she was not sure what to replace Smith with. While I'm not an expert on the Free Exercise Clause, I thought that Barrett was right when she found the historical record more silent than supportive, but that text and structure provided strong support for overruling Smith. I also agree with Barrett that simply applying strict scrutiny in this area would be premature and perhaps unwarranted. Barrett lists a host of issues that should be addressed before determining what standards should apply. Even more importantly, from an originalist perspective, is that standards of review such as strict or intermediate scrutiny are generally not originalist. Perhaps they can be made consistent with originalism if one interprets what a compelling state interest is by considering the type of reasons that people at the time of the framing would have regarded as permissibly limiting the free exercise of religion. Perhaps instead, something else should replace these standards of review. But requiring that the court address these issues before simply adopting strict scrutiny seems sensible from an originalist perspective. In this case and in others, I believe that Barrett had a successful first year. Another recent development that was particularly important in the last year is the turn against originalism by some social conservatives. This turn is led by Harvard law professor Adrian Vermeil, whose book Common Good Constitutionalism actually came out just this month. This turn is an extremely important development since the transformation of conservatives from being largely constitutional Burkeans to being virtually all originalists was a key ingredient in the tremendous growth of originalism as a political and legal movement. This attack on originalism has focused upon the Bostock case, where the Supreme Court held that Title VII protected against discrimination based on sexual orientation and transgender status. Yet this claim that originalism produced Bostock is so weak that it leads one to question whether it is genuine or merely opportunistic. To begin with, although Justice Gorsuch's opinion said it was based on the original meaning, In my view, it was not. In fact, while Gorsuch said he was following the original meaning, what he actually did was follow Title VII precedents that were written by non-originalists. Had he said what he was actually doing, no one would have thought to criticize originalism for Bostock. As an aside, I should note that, of course, my criticism of Bostock on originalism grounds does not imply anything about my policy views. The original meaning of Title VII is a separate issue from what one believes is good policy. Returning to the main question, even if you assume that Gorsuch's opinion was attempting to enforce the original meaning of Title VII, it is hard to blame originalism rather than non-originalism for the case. The majority opinion was joined by all 4 non-originalists on the court, and by Chief Justice Roberts, who is at best a fellow traveler of originalism, and seems increasingly motivated to avoid conservative results that he believes might undermine the legacy of his court. It was the Bostock dissent where the originalists resided. Both originalist Clarence Thomas and Brett Kavanaugh dissented, as did quasi-originalist Sam Alito, who wrote a strong originalist criticism of the majority. No non-originalists were in dissent. Why the Bostock decision somehow is the responsibility of originalism rather than non-originalism beats me. Instead, Bostock is best understood as an excuse for social conservatives to attack originalism, which they dislike on other grounds. After all, Adrian Vermeule has always opposed originalism. It's not like Bostock changed his mind. Bostock can be portrayed as indicating that originalism leads to problematic results for social conservatives, but it is actually non-originalism that leads to such results. In my view, the social conservatives' agenda will be better promoted by following originalism rather than adopting the methods of progressive non-originalists, especially when the social conservatives, unlike the progressives, do not control the commanding heights of the information economy. Finally, another big event in the last year is Justice Breyer's announcement that he is retiring. But while important for the Supreme Court, this is not likely to have much effect on originalism. Breyer rejects originalism, believing that justices should help to improve the Constitution, and his replacement will almost certainly also be a non-originalist. It is true that Breyer's replacement will probably be a bit more left-wing than Breyer, but that's not really an originalist issue. Still, I cannot leave this subject without touching on a Breyer opinion that I believe is one of the worst from an originalist perspective. In the originalist Hall of Shame, if you will, his opinion in Noel Canning. Noel Canning was awful by any originalist metric. In my view, it got all 3 issues it addressed wrong, claiming that a vacancy did not have to arise during a recess, that intra-session adjournments were recesses under the clause, and that pro forma sessions were real sessions. But that is just the beginning. The opinions claim that the original meaning was unclear brings to mind Justice Keene's quip about Justice Foster in the case of the Spelunkian explorers, that Foster's favorite part of statutes were the holes. Breyer seems to have the same view. And let's not forget Breyer's claim that a recess needs to be 10 days in order to satisfy the recess appointments clause. Now, where did he get that from? Didn't you know that the framers really liked round numbers? Of course, the presentment clause mentions 10 days, but the presentment clause has nothing to do with the recess appointments clause. But we really should not put too much blame on Justice Breyer. He was just being himself. Much of the blame for Noel Canning actually rests with Justice Kennedy, without whose vote Breyer's opinion would simply have been a dissent, and Scalia's originalist opinion would have been an originalist triumph. Which allows us to end on a happy note, because Justice Kennedy, not to mention Justice Ginsburg, is no longer on the court. And therefore, originalism is much more likely to prevail today than it was in 2014. Well, putting together a conference of this sort involves a great deal of work, so I'd like to thank various people. First and foremost, I want to thank Mike Ramsey. Mike and I co-plan the conference every year, and I'm extremely grateful for his help. Thanks also go to Dean Robert Shapiro for his support for both the conference and the center. In addition, I want to recognize Stacy Groff, who has helped organize the conference for many years now and does a great job with everything. Finally, I want to thank Rick Stack and the Hugh and Hazel Darling Foundation for their generous support. Their grant to the center has made possible the continuation of this conference, as well as a host of other activities that the center runs. Let me now say a few words about administrative matters concerning the conference. The papers will work as follows. First, the paper presenter will have approximately 10 minutes to summarize the paper. The commentator will then have approximately 10 minutes to give their comments. The presenter will then have 2 to 3 minutes to respond. We'll then open it up for discussion with a cue kept by the moderator. To avoid the situation where the paper presenter responds to every comment made by the participants, the discussion will generally follow a rule of 3. The moderator will allow 3 persons to speak, and then will give the presenter and the commentator an opportunity to respond if they wish. Presenters should not feel obliged to respond to every question, although, of course, they usually do. I also want to urge people not to make long speeches when asking questions. There are a large number of knowledgeable people in the room. Sometimes a question does require a long setup, but often it does not. So if you could please be mindful of this issue when asking the questions, I'm sure everyone will appreciate it.